Trust and estate administration is the area in law where we help trustees, administrators, and executors collect and distribute the assets of an estate after someone's death. This can be a really difficult time, especially if you're left holding the bag of an estate that wasn't properly planned. In cases where there are family arguments or arguments between different beneficiaries of an estate, estate litigation can arise. The attorneys at Burner Prudenti Law are well versed in trust and estate administration as well as in estate litigation and can assist you no matter what comes up. An estate or a trust can hold many different types of assets: real estate, bank accounts, corporate interests, and it's important to have an attorney help you to unravel those assets, make sure all the debts of the estate are paid, taxes are properly accounted for, and beneficiaries are paid out, all while protecting the trustee, executor, or administrator from personal liability. Many people don't realize that all wills go through probate. Probate is actually the process of the courts determining that a will is valid. The probate process also results in an executor being officially appointed by the court. Until probate is finished, there is no executor of an estate, and the terms of the will cannot be followed. It is crucial to have a lawyer that not only plans the estate properly, but also understands all of the things that can go wrong during the probate or administration of an estate to make sure that it's a smooth transition after someone's death. The process of probate requires notification to all the legal next of kin. Now, many people will say, well, my loved one died and I'm nominated as executor in their will, but they didn't have any family. I'm a friend. And what they don't realize is that we must find the nearest level of next of kin in order to properly probate the will. This often requires hiring genealogists and giving certain legal documentation to the court to prove who the legal next of kin of the individual are and how those people are to be represented in this proceeding. In many instances, when someone is doing their estate planning, they will create a trust. But what happens when that individual dies? And that is what trust administration takes care of. Upon someone's death, whether they were the trustee during their life or there was another trustee during their life, the trust document will say who is the trustee after death. This is the person that's in charge. This is who handles all of the assets that are owned by the trust, make sure the assets are collected, properly liquidated when appropriate, debts are paid, taxes are paid, and beneficiaries receive their distributions. In certain circumstances, a trust may create additional trusts. So upon my death, I might state that my trust will create a trust for the benefit of another person, and I want it to continue in trust for them. It is the job of my trustee to make sure that that happens properly. A trustee will also be responsible quite often for cleaning out the home if the home is within the trust, meaning that a deed was signed while I was alive, transferring my home to be owned by the trust, and then putting it up for sale and distributing the proceeds accordingly. These are all issues that require the assistance of an attorney. Understanding what assets are owned by the trust, what debts of the trust exist, and what beneficiaries are to be paid out, all while limiting your own liability, are some of the key reasons that seeking competent trust and estates administration counsel is important. There are many different types of trusts. Many people have heard the word living trust, inter vivos trust, revocable trust. These are all just the same thing by a different name. A living trust or an inter vivos trust just means that it was created while you were alive. It doesn't necessarily say anything about what the trust says and what the trust is meant to do and where anything goes upon your death. There are grantor trusts and non-grantor trusts. These are tax terms. These terms are terms that are assigned to certain types of trusts that will lead to determining where the taxes are paid. So for example, if it is a grantor trust, meaning that under the IRS code, certain provisions are in the trust document, making it so that the creator, the grantor of the trust, is the responsible party for income tax purposes. Well then, when that trust generates income, that income will be paid by the grantor. However, in a non-grantor trust, the trust bears the burden of paying the taxes generated by that trust and the assets within the trust. Trusts pay income taxes in the highest bracket at a very low level of income. So not only is it important when drafting a trust to make sure that the drafter is cognizant of whether the trust is a grantor trust or a non-grantor trust, but it is also important after the death of the individual that a trust and administration attorney understand the tax status of the assets within the trust. There are many different types of irrevocable trusts. Generally speaking, an irrevocable trust is a trust that puts some restriction on the creator of the trust, we call that the grantor, in exchange for some type of protection. So for example, if someone is looking to remove assets from their taxable estate because they believe that after their death, taxes may be owed, in that case, the grantor of the trust, the creator of the trust, needs to lose certain beneficial control and interest in those assets. Another common type of irrevocable trust is an irrevocable Medicaid asset protection trust. While the creator of the trust can retain certain rights over trust assets, such as the right to receive trust income, the right to reside in a property that's owned by the trust, and other certain benefits, the individual who is the creator of that trust cannot be trustee and cannot have any powers that will be seen to allow them to distribute or control the assets within the trust. And in exchange for losing the power to control the trust or the power to receive principal from the trust, the grantor can leave those assets outside of their name for eligibility purposes should they need to apply for long-term care Medicaid for home care or nursing home care. At Burner Prudenti Law, we work with the trustee, executor, or administrator to make sure that things are as easy for them as can be. We want to explain the legal principles, let them know their options, and help them be as efficient as possible in closing up an estate and distributing the assets to the named beneficiaries.